and picking up with a different topic now. We've moved to 265, an act relating to expanding criminal threatening to include threats to third person. And as our first witness, we have Steve Howard from the VSEA. Welcome, Steve.
Thank you. Good morning. For the record, Steve Howard. I'm the Executive Director of the VSEA. Appreciate the opportunity to testify on this important legislation. I want to start by just being clear that the VSEA strongly supports the passage of this legislation. And we feel that really the testimony you heard earlier this week from our member, Shannon Morton, that early intervention is really an opportunity to prevent something more serious from happening. And so we believe that if the actual threats that are made to our members, and they are numerous across state government, that if we're able to intervene and hold people accountable early, we are very likely preventing what could be a very bad outcome later in the process. I'd like to just also respond to some of the other testimony you've heard. It was sort of delicately suggested to this committee that when somebody takes a job as a public servant, whether they're running our elections or protecting Vermont's children from abuse and neglect, that really the assumption or the assertion has been made, not just in the testimony about this bill, but has been made over time in the State House and among managers in state government, that threats really are par for the course, that they should be, you should accept threats as just a part of your job. And that is something that our members categorically dismiss and oppose and find really reprehensible. And I will say there are a lot of threats that come into state government. I think you heard Shannon say DCF had something like 140 credible threats against family service workers. It happens in our correctional facilities quite frequently, and in our probation and parole offices very often, in the Agency of Natural Resources when they're trying to even just test water or look at water supplies or look at potential sources of pollution. There's a lot of that happens in the public sphere, and the threat of violence, which is often the subject of these threats, is not something that should ever be tolerated or accepted. And no manager should ever, and really no Vermonter should ever suggest that this is just par for the course. And so we want to make sure that that is called out, and that is really addressed, as this legislation, I think, does quite well. We have members who are working in a variety of environments. I think you heard from the Secretary of State about a very serious response from folks who didn't agree with the outcome of an election to make threats on the lives of VSEA members who were doing nothing more than administering a free and fair election. So that has some real serious consequences. And in that case, and in many other cases, you've heard from the Secretary of State, and you hear from others that our members experience real anxiety, PTSD, and in many cases we lose valuable and talented people who say, I just cannot put myself or my family at risk. And of course, we live in the shadow always of having lost a family service worker who was doing nothing but her job of protecting children, and recently having a member who was sexually assaulted and really made to feel guilty about whether or not she should be put herself in a situation that she was unsure of, that she felt unsafe with. So whenever these threats occur, if there's no accountability and management thinks it's par for the course, they often go unchecked. So we're very supportive of the original law that passed right after Lara's murder, and we're very grateful for Senator Sears for introducing that law. And our experience since then has been that the affirmative defense has kept it really from being a useful tool that I think the senator intended it to be. And so we are supportive very strongly of the passage of this bill. We think every threat that has credibility really should be taken seriously. It's not always a law enforcement issue, but when it is, we want to be able to make sure that our prosecutors can hold people accountable for what is, I think, universally accepted as unacceptable behavior. It's not part of your job to either experience violence, but it's also not part of your job to be terrorized by members of the public for just doing your job. So we applaud the introduction of this bill, and we strongly support it and hope that the committee will adopt it.
Thank you. Thanks, Steve. Appreciate it. Are there questions for Steve? I want to make sure I understand clearly how the affirmative defense has hurt the effort to protect. You mentioned after Laura Sobel's death. What were you what specifically in the affirmative defense?
I think
I
it's
remember.
I think I don't know that it was directly connected to Lara's murder, although I think the legislation was came about after her murder.
Right.
I think what we have experienced and what we've been told is the aspect of the law where you have to prove that that the person could carry out the threat, intended to carry out the threat, and had the means to carry out the threat. I'm paraphrasing it, but that has what we've been told by prosecutors when we've asked them, are you going to charge this person that is making a threat, is that they don't think they can reach that level, that they can prove that. So they often aren't able to use the law as the tool they hope they would be able to.
Okay. Can you provide Ben with some of that? Ben Novogelski, our legislative counsel, with some of that, so that while we're working on this. I see Shannon Morton has her hand up, and maybe she wants to add to your testimony. Shannon?
Good morning, committee members. Again, my name is Shannon Morton. I'm the staff safety manager for DCF Family Services. So in processing some of the threats that I have received regarding our staff, I have been told by law enforcement that because the person wasn't holding a weapon when they made a threat, that they wouldn't be pursuing it as a crime. And so I think that that's the pieces where it comes into the interpretation, into the actual willingness to investigate certain things, that they're already jumping ahead to whether or not there would be, a potential conviction on something before they will even look into the issue, that no one reported seeing them holding a weapon, and so therefore they didn't have the ability to carry out the threat.
Well, that Senator White.
I understand that. I guess that in my mind, that's a little bit different than the guy who called you and said he was going to do something to you. I don't even remember what it was. And he was in Minneapolis in a wheelchair. So he had no ability to, I don't think that person should be prosecuted, because he really had no, it was an empty threat. So I think that we need to talk about that a little bit more.
Well, can I just suggest that, yes, it was an empty threat, and I felt better after it. But what if I had done something based upon that threat and not knowing that he wasn't able to carry it out? What if I decided to vote no on a bill? Or what if a social worker decided not to take a kid into custody based upon that threat? What if an election worker decided to change the way they counted the votes based on that threat, even though they didn't? Because you don't know it's an empty threat when the threat is made. You only know that it was an empty threat after the fact. and the intimidation that comes along with that threat. For example, the case of the election worker might change their behavior. I think that's why I think it needs to be dealt with personally. But we can certainly disagree about this when we start marking up the bill. Obviously, it didn't change my vote on the civil unions, but at the same time, I don't know. You know, I'm sure that when we've all gotten emails that that threaten us with withholding with they'll never vote for you again if you do this. That's much different than I'm going to kill you if you do this, or I'm going to injure your daughter or whatever, you know? No, that's, I'm just kind of talking off the top of my head, which is not good to do, as we've all found out, but anyway. Great. Thank you, Steve. And we'll try to look into that part of it if we can, Ben, in terms of because you weren't holding a gun, the threat isn't real. I don't understand that.
Yeah, and Senator Sears, we can look into that. And again, this kind of goes to, if I may, just the policy decision about how far you want to take the statute itself, because really the constitutional prohibition on true threats does allow it's there because it protects individuals from the fear of violence and from the disruption that the fear may engender, and also in addition to the possibility that the violence will occur. So the prohibition on true threats is constitutionally permissible, but whether or not the committee wants to take it that far is more of a policy concern. But I can definitely give some more support to that later on.
Yeah, perhaps Shannon and Steve can help us with exactly where state attorneys have declined to do anything.
Okay.
All right. Why don't we switch to markup and remind us of where we're at?
So could I just ask another question? Matt Valerio sent me a list of a number of the statutes that under which a threat could be charged. And I wonder why, and Ben may have a better sense of this, but why they aren't sufficient in this case. There's simple assault by physical menace, disorderly conduct, aggravated disorderly conduct, reckless endangerment, aggravated assault, disturbing the peace by electronic means. So I'm just wondering why these are not sufficient to charge people for threats. I don't know. And Ben may have.
I'd be happy to hear from Ben, but but I think Rory Thibault might be the best person to ask that question of, since he declined to prosecute or declined to do. He can speak for himself, but I think that part of the reason for the bill was what happened to the election workers in Vermont, and he didn't feel that Vermont law was adequate to prosecute on it. So maybe, do you mind, Rory, fielding that question?
Good morning, everyone. Sorry for not having a tie this morning. I was just snow shoveling.
Oh, that's fine. That's fine.
Yeah, I'd be happy to answer that. And in my written submissions to the committee, I think it's about page 7 on it. I didn't expect everyone to go through all of that, but there's what I call the gap analysis. And I'll just say this at the most broad level that a lot of our statutes deal with physical presence when a threat is being made in physical proximity to somebody and there's associated conduct or behavior. So when we talk about disorderly conduct or aggravated disorderly conduct or aggravated assault with threatening with a deadly weapon, that all entails physical proximity of the person making the threat and the recipient of it. Additionally, our Vermont Supreme Court has ruled that those statutes deal with the regulation of conduct. So while the words may be relevant to the intent or figuring out what the context of the situation is, it's the behavior itself that results in criminal liability. So gesticulating wildly or, advancing towards somebody with, fists, threatening somebody, that's the conduct that's being criminally prosecuted and charged. The words in that sense are really just evidence of the intentions of the actor. Really, we have two statutes that deal with or can cover just speech alone. And the first of that is disturbing the peace by electronic means, which implies that it's being done by telephone or by text message or some other remote form of communication. And then there's criminal threatening, which covers that sort of gap, which allows for by words or by conduct. So when we look at what the gap is or where the issues are, really twofold. We have a limited set of statutes that deal with actual speech versus conduct. And then when we are dealing with threats of serious bodily injury, and again, assuming we have a true threat and that it's a true threat regarding serious bodily injury or death, then we're stuck in the trap, as Steve Howard mentioned and others have as well, of the affirmative defense, making it difficult because let's say for a moment that there's a true threat of serious bodily injury by phone. It may take investigators sometimes days to get the relevant information about who the person is making the threat, where they are. And from an investigative standpoint, it can be very difficult to go back and prove or demonstrate at that moment in time the person had the capacity to carry out what they were threatening to do. Absent doing a search warrant in someone's house, do we know if they actually have a firearm or not at that time? Even if there's pictures of them on social media with a firearm, well, is it theirs? Do they have it? Do they have access to it? Do they have control of it? There are a lot of impediments that are presented by the affirmative defense that render the statute incredibly difficult to use. And I agree with Ms. Morton's testimony that I think a lot of prosecutors are reluctant to advance a case that we feel will fail. And, one thing I can say is not every prosecutor make the same decision, but I do think that we're all guided by ethical values, and we don't want to waste the court's time. We don't want to put a defendant through something we know is futile, and we also don't want to mislead victims of crime by initiating a criminal prosecution that we, with a degree of certainty, know is going to be futile or unlikely to result in a meaningful response from the system.
Thank
So
you.
that the real question is not the electronic means, because if I'm reading the language on that, and that seems pretty clear that if anybody is with the intent to terrify, intimidate, threaten, harass, or annoy, it threatens to inflict injury or physical harm to the person or property of any person. So that is pretty clear around telephone and email threats, right? You could prosecute them, but the problem comes in where it's an in-person threat, and there isn't any there isn't any behavior that would. Is that? Am I understanding you?
That is one of the gaps. And then again, looking to go beyond. So disturbing the peace by electronic means includes just bodily injury or property. But when we start talking about a death threat, let's say, that could still be charged under the disturbing the peace by electronic means, but we would have difficulty with criminal threatening again because of the affirmative defense. The other, point as well, there are other things I know the committee talked about during the first round of testimony about, the threats that are not directly to the actual recipient. So it's, I'm going to kill your dog. I'm going to kill your wife or your partner, or I'm going to, for criminal threatening, I'm going to burn down your house. Property isn't currently, captured there. There's also the issue, of course, of reputational harm. In the internet era, it's very easy to fan the flames of false information about somebody to discredit them or, embarrass them. Different things like I'm sure the committee's familiar with things like doxing or, deep fake videos of people saying things that they're not actually saying. These are all phenomena that I don't think we've had to deal with much in Vermont, but certainly at the national level, it's not hard to look and see circumstances where these types of behaviors have been incredibly disruptive. And I'm not saying that necessarily needs to be part of criminal threatening, but there's a broad range of other abusive behaviors that fall under, I think, the disturbing the peace by electronic means that don't necessarily constitute a true threat. We would be looking at that under the lens of this statute for criminal threatening.
So can I, Senator Sears, may I ask a follow-up
Yeah,
question
sure.
on that?
Yeah.
So I got that, but are you saying that captured under this bill should be things like videos or anything that try to discredit you or embarrass you or?
No, not for criminal threatening. I think we're looking solely at the question of where we have, your first ingredient, if you will, of getting to a case is having a true threat.
Okay.
And I will mention that I had opportunity after hearing some of the other testimony, and I think it was valuable. I enjoyed hearing Mr. Valeria's testimony, for example, and I think, getting to the process of what is the right fit for Vermont at this moment takes good perspective. And sometimes I do enjoy hearing the other perspective. And one thing I could say is this: I mentioned to Mr. Novogrosky that the disturbing the peace by electronic means clearly spells out the mens rea element of it being intentional. I think a true threat generally isn't, impliedly a specific intent. Someone is purposely speaking those words, with some intent or not. But adding an intent element, particularly for a felony enhancement, if that's necessary, I think would be appropriate and acceptable. And the disturbing the peace by electronic means statute lays out a list of those things: an intent to terrify, to intimidate, to harass, or to annoy. Those are all things that could be considered, especially in the context of an enhancement. I think to allay some of the concerns that it could be overused or overbroad.
Thank you. Thank you.
Interesting. Senator Benning.
Rory, honestly, I'm on the fence with this one and I'm struggling. My inclination is to be very fearful of creating a new felony. We've already got a felony on the books that if you recklessly engage in behavior that leaves another person in fear of serious bodily injury, there's a felony there available to prosecutors who evidently have not made the connection. Here, clearly, only words are being turned into a felony, and I don't know why that troubles me. And I'm not somebody who's ignorant of threats. I've been a divorce attorney for 38 years, and I've seen every imaginable result in the opposition when a custody battle has been hardly fought or hard fought. I've gotten threats from victims' families. The most recent one involved a manslaughter case about 1.5 years ago. And I brought the tape recording of the family member who had left a message threatening me to the prosecutor, and the prosecutor did not choose to prosecute. But there are things that are available right now, and I'm a little nervous about trying to create another one in an atmosphere that I freely concede has gotten way out of hand. But tell me why we need to have a felony in this particular statute.
If I could ask, just what statute were you referencing about the felony?
Well,
level?
I don't have my, I'm thinking initially of an aggravated assault. What is the behavior that rises to a level where somebody is threatened with serious bodily injury and interprets that as such on the receiving end? You get into conversations about, does that meet the same kinds of threats that we're here talking about? And there's obviously been a reluctance by prosecutors to bring a charge under that kind of a statute. I'm trying to figure out why.
Sure. So looking to 13 VSA 1024 subpart A1 requires and states this, that there's an attempt to cause serious bodily injury to another or causes such an injury purposely, knowingly, or recklessly under circumstances manifesting extreme indifference to the value of human life. For an attempt, case law, and I know the committee dealt with this several years ago when looking at domestic terrorism, attempt requires more than just words. There has to be some action put into effect. The statutory regime of 13 VSA 1024 also, I believe, requires presence. The only other part that deals with any kind of threat is subpart 5, which is armed with a deadly weapon and threatens to use the deadly weapon on another person. It's difficult to divine that someone is armed unless in physical presence and or I just have never seen anybody try to apply the statute in that way, and I'm not sure that a court would really entertain that. The one area, well, I'll segue to that I think is somewhat analogous to the situation. We already have a felony in effect for obstruction of justice. So if there's a threat made to a juror, to a judge, or to a witness in a court proceeding, we hold that as something very serious. And I think there are certainly circumstances where threats directed towards state employees or legislators or members of our executive branch can cause the same amount of disruption. And certainly we want to make sure that a trial process is clear of undue influence and or things that threaten the ability of a witness to discharge his or her duty or a judge to do his or her job. And I think ultimately it is a policy question, but when someone is threatening to cause significant harm at the state house or at a school, for example, the option to have Brady disqualification as a collateral consequence can be important, particularly when gun violence is being implicated. But again, that's a policy question ultimately for the committee and for the legislature to work through. But from my perspective, it's territory that's already covered in terms of when threats are made against the judicial process. And it would be, I think, appropriate to consider that in the context of the legislative and executive processes as well.
Well, in the case of a DCF worker, would you consider a threat to that individual as part of an obstruction of justice charge?
It depends on where the case is in a proceeding. There are a number of DCF actions and DCF interventions with a family that are short of there being an active court case or even a contemplated court case. Ms. Morton could probably attest more to that, but there are a lot of circumstances where DCF is involved or has an open family case, for example, supporting a family that does not have any judicial element to it and may not even be projected to. And also DCF is a broader umbrella. There's also the Office of Child Support. I think those employees are often stuck in the middle of really difficult, sometimes custody battles and support agreements between families. And certainly there are other state employees that find themselves in the thick of contentious issues in families outside of DCF as well.
Senator White.
So remind me, and I hate to be so dense on this, but why 1702 criminal threatening it's already a felony to threaten another by words or conduct, threaten another person and put that person in reasonable apprehension of death or serious bodily injury. So is the problem here that it doesn't cover groups of people, or why is this not enough to prosecute? You probably explained that 4 times, and I just.
No, it's okay. I'm glad that I have only to deal with one part of the criminal code. I know the committee has to deal with a lot of issues beyond just what we deal with. So one thing I'll say is this: so 13 VSA 1702 is a misdemeanor for either
It's
outcome.
1 year or $1,000.
Correct. In terms of gaps, I would say this: that the bigger questions are, and Ben might be the best one to describe this, and he already did so to some extent, of the gap between what is the constitutional limit of what can be charged versus the statute here. And I think as the statute's currently drafted, it leaves a lot of circumstances out. I did send out that gap analysis slide to show the areas in which there are difficulties. The first and foremost of that, again, is the affirmative defense. Some of the other issues, of course, then are the more indirect threats, again, to a family member or towards a group when that person may not be direct part of it or may not be directly threatened. So that can still have a huge and disruptive impact on legislative executive process or of the conduct of individuals. I think I think a lot of people have acknowledged this in public service. I mean, I've been threatened in my official role as prosecutor. It's probably no secret. We have a lot of people who don't leave court always super happy with us or with our team. But there's a difference for me, at least, when the threat is directed towards me versus when it's, a threat about doing something to my children or to my spouse or and that can have the same effect and disruption and the ability to do things. So broadening the scope to include discrete groups, which I think is important. I think Senator Baruth made that point of language about particularity. I think that's important. We want to make sure that there's not overbreadth. And for example, if I'm going to kill all legislators, well, that may be too broad. What U.S., Vermont, but saying particularly like the Senate Judiciary Committee, well, that's a very discrete and particularized group of people. And so that's when I refer to a gap analysis or where there's some gaps. That's just it.
So one more question, if I may, and then I promise I'll try to keep myself under control. That Philip, don't laugh. So if this bill says it is only going to be have this enhanced penalty if the threat is intended to occur at a place of public accommodation. So if somebody threatens your children, that wouldn't be covered under this bill, because it says that they make a threat that places any person in reasonable apprehension that death or serious bodily injury will occur at a place of public accommodation. So I don't get that unless that's covered in A, that if it's any person or group of persons, and then there's an additional thing if it's supposed to happen at a place of public accommodation. Is that the way this reads?
Yeah, so to help clarify that, so I think that right now, adding threatening another person or group of persons, that could, the language fix, I think, at the misdemeanor level would include, the family members or other people there. The enhancement is based upon, actual infrastructure. And after hearing the last round of testimony and the concerns about, correctional facilities, for example, and other things, I just want to emphasize, I think the main point is, or at least from my perspective, the main point is to try to have some means to deal with threats that are directed towards really critical public infrastructure. And I would include in that the state house, state office buildings, schools, churches, and then locations where election activity is occurring as heightened. I would agree, I think, on analysis that the public accommodation, while it would capture those places, may be broader than what the committee wants to do. And I think those points well made about bars or restaurants being included in that. But I think the goal here, one of my goals, I guess, in proposing some of this and discussing with our stakeholders is to, in some ways, bridge the gap between where criminal threatening ends and where the domestic terrorism statute begins. And that's particularly critical, again, when we look at threats that are directed towards the school community or inside of schools by outsiders, threats directed towards a state office building, et cetera, or a class of, state employees, let's say DCF workers. I'm going to come shoot up the DCF office if that were, had the circumstance being a true threat. That's more disruptive than just threatening one person. It really causes a mass disruption to an entire agency or an entire office. And so I think this is a mechanism to do two things. One, broaden just the base misdemeanor scope of what the statute covers, and then also carve out an enhancement when it does impact some of that key or critical infrastructure in our state government.
Thank you.
And I guess if we boil it down to other sections of the bill where we make changes, like in section 1, a group of persons, to other person, a person in the group of persons or any other person. Ben, I'm asking you, and we drop for a moment the whole enhanced penalty, because we could either go with the McCormick bill or our bill or a combination of the two. The McCormick bill, as I understand it, provides an enhanced penalty for election for certain government employees, or is that correct?
Yeah, it's public servants, public officials, and election workers.
But for me, it was important that We also talk about the store owner who's trying to enforce a mask mandate, whether he or she agrees with that mandate. They're trying to enforce it in Brattleboro, and they get threatened with all kinds of things for doing that. We've seen cases where people have been punched, etc. So I would like to have us focus on other changes in the bill and then come back to what we want to do for an enhanced penalty, if we want to do any enhanced penalty. Because I think what Rory has done with his excellent slide presentation that is very well done has provided us with, the gaps in current law. So is that good for the committee if we kind of go through all the other sections, then talk about the enhanced penalty and who should be part of that enhanced penalty? If we have one, should it be 3 years, 5 years, 20 years, whatever? Right. So why don't we start at the beginning? The first change in current law is in section 1, adding a group of persons. Any thoughts on that? And I'm inviting people who are also in the room: Matt Valerio, Harrison Stark, Rory, Shannon, if they have comments on that particular section 1, A1 and 2, which is threaten that another person or a group of persons, is added to the statute. And then as a result of the threat, place another person in reasonable apprehension of death or serious bodily injury to the other person, a person in the group of persons, or another person, which I would guess could be the wife, could be the child.
I think that Philip had talked about that being too broad, and it should be something like specific group of persons or something, because a group of persons could be, as Ben said, the entire legislature.
Yeah, that was I think it was the ACLU's suggestion to use group of specific persons.
Senator Sears, if I may, for one moment, I kind of have a running tally of different points that have been discussed. This is one of them. I can go through them, or you can lead.
Yeah, why don't we? That would be helpful if you give us the running tally on that.
Sure.
On section 1, A1 and 2.
Yeah. So in section 1, A1 and 2, you identified one of the discussion points was the phrase group of persons, and a particular group of persons was a suggested remedy, I think, to revise that to subdivision 1 and subdivision 2. So, if that's something that the committee would like to see incorporated in the markup, I'm happy to do that, or if there's some variation of that as well.
That would the adding the word particular before so it read threaten another person or a particular group of persons, and then in line 19 would be to the other. How would you word that?
Yeah, I mean, the intent would be to keep to the other person on 19, and then onto 19 and 20 to add a particular group of persons or any other person.
Okay.
Yeah. Is particular better than discrete?
Particular is actually more in line, I think, with the case law itself. Okay. So I think that would be a better word choice than discrete.
Okay, thanks. It just didn't
Harrison Stark has a comment or question.
Thank you so much, Senator, and I appreciate the opportunity to be here today. Just one small comment. I know that
when you first speak, it'd be important for the record to state your name and affiliation, and then we have it for the record. When we do these types of things, some people forget who it is speaking.
Absolutely. My name is Harrison Stark. I'm a staff attorney at the ACLU of Vermont. We testified earlier this week about this particular section. One of the solutions that we'd suggested was a particular group of persons. I think if the committee is amenable to it, an even better formulation that tracks the Supreme Court's case law in this area a little bit better would be a group of particular persons. So to move particular from referring to the group of persons to the individual persons. And the reason I say that is just because the definition, again, from Virginia v. Black, which is the sort of clearest articulation the Supreme Court has said on this, is serious expressions of an intent to commit an act of unlawful violence to a particular individual or group of individuals. And so I think the particularity being pegged to the particular persons, I think is probably the closest legislative formulation that tracks the Supreme Court's articulation.
Actually, Rory does cite the Black case, Virginia v. Black, on about the fourth page of his the wording is unlawful violence to a particular individual or group of individuals. Any other comments on that particular wording? So it would read, could you read that again, Ben?
Sure. So division 1 of subsection A would read, threaten another person or group of particular persons, using the suggestion of Harrison Stark. And then in subdivision 2, as a result of the threat, place the other person in reasonable apprehension of death or serious bodily injury to the other person, a person in the group of particular persons, or any other person, excuse me.
Right. Does that work for everybody? It sounds a little
Yeah, sounds weird.
wordy there, so when we see it in writing, we know.
Person.
Got it. But is there any?
Works for me.
Okay. Turning to page 2 and skipping the changes in terms of D. In E2 or in E1, serious bodily injury, we strike shall have and insert has the same meaning. I guess that's just technical.
Yeah, that's more just stylistic than substantive. As far as serious bodily injury, though, this wasn't a revision in the initial bill, but it was discussed whether or not injury, as opposed to serious bodily injury or death, be a choice that could be employed. Injury is the language that's used in the federal statutes, but that wasn't something that was an initial suggested amendment, but it was a discussion point based on the testimony that was previously provided.
Serious.
Are you saying that we should use just injury instead of serious bodily injury? Is that what?
I'm not necessarily.
No, I mean, that's a choice.
That's a choice to take out the word serious. But I think injury could be that, I don't know, throw a rotten apple at somebody, or rotten egg, I suppose there's an injury.
Yeah, or I'm going to break your nose.
Well, that'd be serious.
I don't think breaking your nose is serious, but
I do.
no.
Yeah,
Not with my
I
nose.
believe. I'm sorry. I'm talking about under current law. Serious bodily injury would include breaking somebody's nose, would it not?
Well, let me just quickly look up the definition in section 1021. So serious bodily injury means bodily injury that creates any of the following: a substantial risk of death, a substantial loss or impairment of the function of any bodily member or organ, a substantial impairment of health, or substantial disfigurement, or strangulation by intentionally impeding normal breathing or circulation of the blood, by applying pressure on the throat or neck, or by blocking the nose or mouth of another person. So breaking someone's nose probably does not rise to the level of that. It has to be pretty significant impairment of your bodily function.
Yeah, well, if we're gonna, I'm fine with using injury and striking out serious bodily injury.
I'm fine with leaving serious bodily injury.
Well,
I think that just saying injury is way,
How about bodily injury?
huh?
How about bodily injury? Leaving,
Neck,
taking off
neck-
seriously instead of just injury, have bodily injury. At
I
least-
think it has to be serious bodily injury. I,
I'd like to go the federal statute as much as possible.
Well, and if I may, Senator Sears, the federal statute does change because there is a different mental element associated with it. And it is kind of, you know, I know that we wanted to separate the discussion about the enhanced penalty, but
Yep.
it could be related if the committee chooses to go that way. And again, I'm not bringing this up to suggest that it should be changed, but it was something that was at least discussed.
No, well, and it's up to the rest of the committee, obviously, but right now there's one for injury, one for serious bodily injury.
Yeah,
I'd leave it intact the way it is. It's current law.
okay.
All right.
I would agree there, because I feel like we run less risk by changing that. So even though I see where the chair is going, I guess I don't see a real need to change that, and I think we're probably better off leaving it.
Okay. In 3, that's just a technical amendment. So we leave serious bodily injury has the same meaning as section 1021 of the style.
Okay.
Okay.
Number 2, threat or threaten do not include constitutionally protected. That's just a technical, am I correct?
Yeah, correct, Senator Sears. Now, you had asked in the last round whether that provision is legally necessary, whether or not to,
Yep.
whether we should include it or not. You know, legally, it's not necessary. For lack of a better term, I would categorize it as sort of comfort language to say that this is not aimed to sweep in potentially constitutionally protected conduct. So that's, again, sort of a policy decision if we want to remain with the current language as much as possible, or removing it altogether, which this may be a tad speculative, but that could be viewed almost as a legislative intent to take that language out. And if we're removing language and expanding the scope of a statute, there could be some interpretation in a court case about why that was done. And we don't really know what that would do.
Yeah, we just learned a lesson on retroactivity in the midpoint probation review. I'd suggest we leave it in and not leave doubt to the court.
So
Senator Nika.
I just have a note next to this that James Lawton says this should be taken out. I don't know who James Lawton is. I don't remember.
He's Kaya's husband.
Oh, okay. Okay.
And we're going to skip over number 3, which is place of public accommodation. I do have one question on line 18. It says under 18 years. We've done raise the age, so wouldn't that be under 19 at this point?
Yeah, that's something I would have to look into the exact changes that have been made, but yeah, part of this would be to keep it in line with what the current limit is.
Yeah, I believe it'd be under 19 as of last July.
does it make sense to reference back to what that is instead of having to come back and change it every year, every 2 years?
Yeah, again, I'd have to review the statute, but it might be a cross-reference to the statute might be more effective than just listing the age itself.
Yeah, it might be, because that if we don't pass the raise the age bill this year, then 19 under 19 would be the new law,
Mhm.
July 1. Okay, so it shall not be an affirmative defense to charge under this section that the person did not have ability to carry out the threat or did not actually intend to carry out the threat. And that's from a U.S. Supreme Court decision. We've had quite a bit of discussion about this.
I have a note here that Matt Valerio said, I think this is what he said, just take this out and don't make it an affirmative defense, but don't limit the ability to use it as an affirmative defense. So you're just being silent on it. You're not saying it is an affirmative defense, but you're not saying it can't be used that way in a case.
Anybody else want to comment on that, either on the committee or in the audience?
Yeah, I would.
Senator Baruth.
I also think Matt makes a good point there. I think it's better to be silent on it altogether. So I presume that means striking G in its entirety. And I would favor that.
I agree.
Well, I'll be in the minority on that one, but it's okay.
How will it, can you explain to me how Matt feels it will work if we take this out?
Matt?
Maybe
Matt's
Matt
here.
should explain it.
Matt's here. Oh, sorry, Matt's here.
Comments regarding this section when it was apparent that that this language is specifically saying that certain defenses don't exist. In the course of any trial, there are common law defenses or defenses that might arise as a result of case law from the Supreme Court, our Supreme Court, or the U.S. Supreme Court. But when you specifically limit or prevent a defense by statute, it potentially takes away something that might be otherwise allowed by law, either by the U.S. Supreme Court or by the Vermont Supreme Court. And if you remember, one of the things I was asking for in conjunction with this is that if you are going to, and I know that you're kind of waiting for the enhancement issue, but if you are going to maintain this as a 5-year felony, I was asking that if take this out and make it an intentional act as opposed to a strict liability crime, which is what you are doing right now. So, but either way, this is, if you take this out and leave the defenses that are available under case law available to people who are charged, that's clearly better than prescribing the defenses that are available to them by statute.
Okay, thanks.
Dick, you're muted.
I'm muted. I was just muted and talking to myself and didn't even realize it. The next one is the actual take effect on passage. I think that's kind of a no-brainer. Can we agree on that?
And
Senator Nika?
can we just go back to where we were? Are we leaving crossed out the burden shall be on the defendant to prove the affirmative defense, or just that gets crossed out also?
That gets crossed out also, I think.
Okay.
All of G gets dropped,
Okay.
right?
Yeah, that's the majority of the committee. Note that the chair was not convinced.
Thought it was rather comforting to people to have that in there.
I did too. Well, so I'm just looking at S-230. That's the McCormick bill.
Oh, we have,
McCormick Perchlik. And they define the enhanced penalty. I mean, basically, they don't do any of the things we did in the bill that we've already covered and agreed to. But the key thing there is their enhanced penalty. So maybe when we look at this next week, Ben, we should probably have a copy of the S-230 to look at in terms of enhanced penalty. And we still have the decision to make about who would be eligible for the enhanced penalty. Again, that seems to me we've narrowed it down now to that area of the bill. Is everybody okay with that?
take a look at that, yes.
We'll take a look at S-230, S-265, and decide whether we want an enhanced penalty at all. And if there is an enhanced penalty, who should be covered under that enhanced penalty? And then I think we go ahead. We've got pretty much the rest of the bill covered.
Okay.
So Senator Sears, just to make sure I've got everything covered, I'll come back to with next week with a markup that we've made so far of S-265 and a copy of S-230 to help inform the discussion on the enhanced penalty.
Yep. Senator Brew.
Just want to make sure that I'm understanding what we mean by enhanced penalty. So the question for me about the bill as drafted was the idea that there was this 5-fold penalty for place of public accommodation. Is that what we mean by the enhanced penalty?
In S-265, that's the enhanced penalty. In S-230, the enhanced penalty covers election workers, public employees, and am I missing a group there?
Yeah, I would be, and I know we're going to have this discussion, but just for Ben when he's drafting, my issue is if somebody makes a threat and then they tack on, look out when you go to McDonald's because that's where I'm going to do it. That's the problem for me. So I guess what I like better about the McCormick bill is that it's zeroing in on what we seem really to be getting the evidence about. I understand the chair's desire to have the mask mandate confrontations taken in, but it just seems the approach of making the place of public accommodation and the mentioning of it what invokes the penalty. That's the legal approach that I'm having trouble.
I'm just going to ask a question here.
Yeah.
So if you have a neighbor that you don't get along with, and that neighbor has an old car, and they put a target on that old car, write your name on it, and then use it for target practice. Is that intimidation? Is that a threat? I mean, I would take it as a threat. And so, that's one example. Now, that may not be a place of public accommodation, so it might not cover, but.
Yeah, and that's really the key with the enhanced penalty and the interplay with public accommodation is that where it would allegedly happen. So if for some reason you're fearful that when you get in your car, maybe something bad will happen to you, that would not be a public accommodation as it's currently written in the bill. There was public accommodation truly is any public space, which would include a government building. There was concern over correctional facilities and how they would be swept in. And so I think some options to consider as we go forward would be, do we want to do a carve out of correctional facilities or some others, or do we want to do an enumeration of specific facilities that the committee is specifically concerned about? Or do we want to create our own definition of what place of public accommodation is and not do a cross-reference to the other part of the law?
Yeah, I think that's, Marley's in agreement with you, Ben.
Again.
I think that sets us up very well for next week when we come back to this. So we're really down to that type of issue as who, I would want to make sure that somehow that we've covered that particular situation, because what I'm describing is really the Slate Ridge, where the neighbors have been intimidated.
Yep.
That's where I get a little nervous. I mean,
well,
one of the hallmarks of our Constitution requires all of us to be tolerant of another person's idiotic moves. There is a line that gets crossed at some point, and I'm just not sure where that line falls in this particular situation, where it crosses from being tolerant of idiocy to actually having to rebuff something that is a real threat. And I'm having real problems with the way we've got this set up right now. A place of public accommodation to me means a parking lot. I think we've been provided with evidence about certain state employees that are definitely being threatened in such a way where the function of their job is problematic. And I can concede to that in trying to do something here. But I get really nervous if my neighbor is being an idiot. Do I create a felony because my neighbor is being an idiot? But I don't know. I just, that's where my brain is going, and I'm hoping we can clean this up somehow.
well, I hope so too. But I will point out in terms of parking lots, if you've ever been to the state employee parking lot at the Springfield State Office complex, that's certainly a scary place to go get into your car.
Yeah.
Yeah, but I don't think the place is what we're trying to take care of. I think the government functioning properly is actually our target of concern.
Well, yeah, but maybe if I'm asked to enforce a public order, the mask mandate I'll use for an example, and I'm the store owner and I'm threatened because I'm trying to enforce that public mandate.
Yeah, I hear where you're going. I think that's the place that we can reach consensus, is that
Okay.
someone is trying to carry out a government instruction. And when that particular effort is impeded, I think that's the target of what this entire bill is all about, not where it actually happened, but the ability of a person to carry out a government instruction. When that's what's impeded, that's what we should be curtailing.
Well, I think there used to be a show. Senator Benning, you have the final word on that subject. So, thank you all. We'll see you sometime next week to talk more about public accommodation and who's covered and who's not. But I think we made good progress today on this bill. After all, it is a simple 3-page bill. And people, if you get a chance over the weekend to read Rory's outline here, it's very helpful, I find. He's done a terrific analysis of the issues. Thank you. We're going to switch now to Judge Zone to introduce to us a person who really needs no introduction, since he's been before this committee dozens of times in various capacities over the years.
So good morning, Tom Zone, Chief Superior Judge, and I am pleased to introduce today Judge Howard Calpis. I will not go into a long background because it appears as though the committee knows Judge Calpis, but I'd like to point out just a few quick things about him that you may not know. He graduated from Seton Hall Law School. He then came to Vermont, was in private practice, worked for the Attorney General. He worked for the Department of Public Safety until 2011 as staff counsel. And at that time, we had the pleasure of him joining the judiciary as a Judicial Bureau hearing officer. He served in that capacity until his appointment to the bench by Governor Scott last spring. I believe it was in June. During that time, he did not sit idly by and take every moment in his life and go enjoy it when he wasn't at work. He actually went and got a master's degree in judicial studies from the National Judicial College. And his thesis was something that was not only for his education, but it educated us here in Vermont about timelines and juvenile reunification in our cases. And so he's offered quite a bit to the judiciary in that regard. And while he's been before your committee, I suspect you may have also heard him in other places and not even realized it. And that's because Judge Calpis, in addition to being a judge, is a professional percussionist. He has played throughout Vermont and New England in symphonies, pit orchestras, and I believe he's also done some juvenile things for kids organizations to help them out too. It's my pleasure to introduce Judge Howard Calpis.
Thank you, Judge Zone. All of those things I was not aware of, particularly being in the orchestra pit. So very interesting. And welcome, Judge Calpis, and welcome back to Senate Judiciary.
Thank you.
It's been a while since we've heard from you, but now you're a real, I was going to say real judge. As
Fair
this
enough.
traffic court wasn't enough. But welcome back, and maybe you want to tell us a little bit about your experience and why you're willing to take on this new job.
Sure. Thank you. Well, first, thank you all for taking the time to meet with me. Judge Zone, thank you for that overly generous introduction. I do appreciate it. As Judge Zone said, the last, it's back about 10 years that I was with the Judicial Bureau. During that time, I was hearing not only traffic cases, but there were times when I was being specially assigned basically as an acting judge in the Superior Court, sometime for months at a time, because the Judiciary has just been down judges, through retirements and other reasons. As Judge Zone said, I with my master's degree, I focused on a study of the juvenile docket. It's always been a passion of mine. As an acting judge, I actually sat in every county hearing juvenile cases. The study was focusing on the impacts that continuances have in how quickly families are reunified, and sometimes if is there a correlation between too many continuances and children just never coming home. And so the passion for the juvenile docket is probably the greatest driver. But I've, for the better part of my career, since graduating law school, Judge Zone mentioned private practice. I'll admit that I've had 2 stints in private practice. The first lasted 6 months when I was on my own before I got hired by the Public Defender's Office in Burlington. And then I had a stint before public safety for about 7.5 months. Otherwise, I've spent the last 25 years in public service, which I feel very strongly about. I think that we need people to step up, and I want to be able to do it in this capacity. And I hope that the experience that I bring as a trial attorney, as a hearing officer of the Judicial Bureau, will help to make me at least a decent Superior Court judge, if not a good one.
Can you, I'm fascinated by your study of the juvenile system. Obviously, I worked in that system for years. Right now, we're in kind of a crisis mode, I would say. in terms of the DCF and particularly DMH and placement of juveniles. The pandemic has created a real horrible situation in many cases where kids are being placed in the wrong place. The system of care is broken. As a judge, and now as somebody who's really studied that system, do you have suggestions?
I see, we have hearings from time to time on related to out-of-state placements. Certainly seeing more of that today than I ever did, either when I was sitting in juvenile court previously or when I was an attorney representing these kids and sometimes parents in those cases. I think we need to take a hard look at the resources we have here and how do we take advantage of what we got here without this knee-jerk reaction to say we need to build more services here. It's really easy to say that. We lost Woodside, and we're scrambling to try to find another way that we can keep those highest risk youth safe, keep the community safe. Every time you open the newspaper or you watch the news, we're talking about the lack of resources here in Vermont, and woe is me. And we certainly have a lack of resources here. Don't get me wrong. But we really need to focus on, are we keeping tabs on the out-of-state placements? Because there are some really good programs out there that are not that far from Vermont. And so it's in some cases, it's not really overly burdensome. And why are we going to try to reinvent the wheel here in Vermont? It's probably not the best use of resources. We do need to up our game here in Vermont. There's no question about that. But I think that we really need to take a broader look of what resources are available. If there's a really great placement in central Massachusetts, are we better off spending our time and energy trying to recreate that here? Or should we be trying to figure out a better way to allow parents to see their children who are placed there?
Well, I'm talking with some folks, even kids that are placed in that, if you're from Newport and you're placed in Bennington, it's versus being somewhere in central Massachusetts, it wouldn't make a heck of a difference. You're still quite a ways. My dog has got somebody's stuff.
I agree. It's as much of a hardship in many cases for, as you said, the Newport kid to be placed at 204. The parents can't reasonably get there.
No, but on the other hand, Zoom is working quite well for them to visit, by the way.
Yeah.
There is that, but yeah. And you're in Newport right now?
Rutland.
Oh, Rutland.
Yeah.
Good for you. Where's your home?
Colchester.
Colchester. Yeah, that's quite a hike.
Well, my folks are in Rockingham, so it's a nice opportunity for me to spend some time with them.
Mm-hmm.
Good. Other questions for Judge Calpis?
Just a couple of comments, Judge. First, my condolences that you have Senator Mazza as your official representative in the legislature, but
it's rough.
I was sworn in back in the mid-1980s and spent probably the first 20 years of my career in the juvenile court system. I have met virtually every juvenile attorney, SRS, then DCF attorney, every judge involved in the juvenile system, state's attorneys, parents' attorneys. I have never, until just now, heard anyone say they had a passion for the juvenile docket. So more power to you, and thanks for that breath of fresh air.
Thank you. I truly love it.
Senator Nitka.
So, we certainly know you from our committee in the past and what a hard worker you were. And I know we've read about your marathoning career, which is absolutely incredible. I remember that you've run in 27 marathons.
Well, that I did.
26. Very good.
So, you have a lot of discipline, and I'm wondering, given that you are such a disciplined person, how are you going to be managing, or how are you now managing, the burden of all the issues that come up in the court and keeping up to speed on all of them and getting, decisions done in such a timely manner? Is that going to cause you heartburn, or how's that going to work?
I'll be honest, I've already put in about 48 hours this week at this point. They're long days. A great mentor for me has been Walt Morris, a retired Superior Court judge, who's also a marathoner. And after I'd been appointed and sworn in by Governor Scott, after about 2 months or so, I had a conversation with Judge Morris, who gave me some really good advice. He said, the staff has to know that from 12 to 12:30, you're off limits, and they can put whatever files they want on your chair, your virtual chair, as it were. And that's your time to go out and go for a short run, clear your head. And it's been great advice those few times that I've applied it. I've got to be better about doing that more, but it's all about finding a balance. Fortunately, my kids are out of the home. And so it's not overly burdensome for my family for me to be at the courthouse until 6 or 7 o'clock at night, which I hope to not be doing every night. But if that's what it takes, I'll do it. And I have been doing it.
I'm very glad to hear that you had Walt Morris as your mentor. We call him Wally here in Lindenville. He actually lives right across the valley outside my window here from me, but you've had a very excellent mentor.
I call him Yoda.
Yeah, that would work.
Well, whatever we call Judge Morris, I still call him Judge. But I had no idea you were a marathoner and running 27 marathons. Have you ever done the Boston Marathon?
Twice.
Wow.
Yeah.
Well,
not my favorite marathon. It's very crowded, but it's the granddaddy.
Well, you ran right by the place I used to live in Ashland, Mass.
Oh, sure.
That followed you down the hill from Hopkinton.
Right. Still feeling.
I remember as a kid going around the corner and watching the marathon, and on Patriots Day, back then it was, I think, April 19th. And we would all get out there and watch them run. And, a little smaller back then when I was a kid, but amazing.
Yeah, it's a great marathon to watch.
Yeah. Yep. Some days it was 90 and some days it was 40.
I'll take 40 any day.
Yeah. Senator Nick, another question.
So you just, I saw you were part of, you were on the screen during part of our last discussion. Just maybe give us a little take on the court and handling threats. Have you had any threats at this point? Or certainly in the traffic court, maybe. But
Are you talking about threats to court staff?
Yeah.
Court staff, the court, yes.
So not firsthand. I'm trying to think. When I was sitting up actually in Caledonia, before the pandemic, I spent about 9 months covering the juvenile and RFA dockets in the Northeast Kingdom. And there was a gentleman who was, that's probably not a good word. He's not a gentleman if he's threatening our staff. But he was making pretty overt threats. We were all on high alert. It's terrifying because even though I know that in order for him to get to any of our staff, he's got to get through that front door. But I will say that I think we as a state, and it's not limited to the judicial branch, I think we're probably too complacent. Our government buildings, be it courthouses, be it state offices, don't have the security that we probably need. We've got a state where there are a lot of guns, and I think it's scary. I really worry about our staff, particularly this time of year when it's dark when they're coming, it's dark when they're going. We've got a problem. Again, not limited to the judiciary. It is a statewide crisis.
Well, that's a good segue for next Friday's agenda item on courthouse security and transport deputies and so forth. Trying to make recommendations to the Appropriations Committee. So, if you've got thoughts, send them to Judge Zone or Justice Eaton. I think they're both on the agenda for next Friday.
Will do.
We've confirmed our attendance.
Great. Well, we'd be happy to hear any thoughts that Judge Calvis has on the subject. Any other questions or comments for Judge Calvis? It's great to see you back, and the best of luck.
Thank you. It's great to see all of you as well. Be
I
safe.
don't think there'll be a huge problem getting 3 votes out of here, but we'll see how it goes. It might be touch and go.
My fingers are crossed.
Okay. Good to see. Thank
Senator
you.
Sears, I understand that the vote will be on Tuesday at 11:30. Would you like each of the
Yep.
judges to also be present at that time?
No, I don't think so. If you're here to answer questions that somebody on the committee might have, that'd be fine.
That works. Thank you.
Thank you. You could keep them on speed dial though, if something came up, a particular question, but I don't think it'll be necessary. I don't want to take them away from their noon hour.